Now, Mr. Sarr also reached for the case Marbury versus Madison as evidence of presidential immunity.
And Marbury against Madison itself provides strong evidence of this kind of immunity, a broad principle of immunity that protects the president's official acts from scrutiny, direct sitting in judgment, so to speak, of the Article III courts. That matches the original understanding of the executive.
In fact, Marbury said no such thing. The court found the authority, therefore, given to the Supreme Court by the act establishing the Judicial Courts of the United States to issue writs of mandamus to public officers appears not to be warranted by the Constitution, and it becomes necessary to inquire whether a jurisdiction so conferred can be exercised. What the Marbury court actually found was that Congress could not give the judicial branch the power to order public officials around. A writ of mandamus is an order by the court to an official to perform their duties. Since the official in this case was a member of the executive branch, a constitutional branch of government, Congress did not have the authority to grant such power to the courts. In response to a question from Justice Jackson, Mr. Sarr brought more evidence to support his position.
I would quote from what Benjamin Franklin said at the Constitutional Convention, which I think reflects best the founders' original understanding and intent here, which is at the Constitutional Convention, Benjamin Franklin said, "History provides one example only of a chief magistrate who was subject to public justice, criminal prosecution, and everybody cried out against that."
I found the quote Mr. Sarr mentioned in Farron's record of the Federal Convention of 1787, and it seems to say something quite different. The Congress was debating whether or not to remove from the impeachment clause that a president could be removed from office on impeachment and conviction for certain behaviors. During the debate, this was recorded in the minutes. Dr. Franklin was for retaining the clause as favorable to the executive. History furnishes one example only of a first magistrate being formally brought to public justice. Everybody cried out against this as unconstitutional. What was the practice before this in cases where the chief magistrate rendered himself obnoxious? Why, recourse was had to assassination, in which he was not only deprived of his life, but of the opportunity of vindicating his character. It would be the best way, therefore, to provide in the Constitution for the regular punishment of the executive when his misconduct should deserve it, and for his honorable acquittal when he should be unjustly accused. This was not a discussion of criminal or even civil immunity from prosecution, only whether there would be a mechanism to remove the president from office in the Constitution. Yes, people cried out at the idea of removing the president, but I think Mr. Franklin provided a very good reason why he thought impeachment should remain in the Constitution. Seeing as removal from office on impeachment and conviction remained in the document, I would say Mr. Franklin's position was the one adopted. Mr. Sarr also called on George Washington's farewell address to bolster his opinion. Washington did warn about the alternate domination of one faction over another, sharpened by the spirit of revenge natural to party dissension, and how these have led to frightful despotism. He even went so far as to describe how that might happen. The disorders and miseries which result gradually incline the minds of men to seek security and repose in the absolute power of an individual, and sooner or later the chief of some prevailing faction, more able or more fortunate than his competitors, turns this disposition to the purposes of his own elevation and the ruins of public liberty. If there is one position in this case that Mr. Washington seems to be warning about, it's the idea of consolidating power in the presidency. Perhaps that's one reason why the idea of presidential immunity does not appear in the Constitution.